it may not matter. It all depends on family dynamics, but it's something that needs to be stated anyway. What happens is that mom or dad, usually as a widow, puts a child's name on their accounts. Now, I don't really mind the checking account where the Social Security goes and some bills are paid. But what ends up happening is that they start that way, and then we find that the child's name is on brokerage accounts. And I'm not saying just as a power of attorney. I'm saying they own the brokerage account jointly with their parent. And this can create some issues. The major issue is that when mom passes away, the account goes to the child whose name is on that account automatically by operation of law. So it doesn't matter what the will says. Okay, so in my slide, I say, even though they love all their children equally, because if you looked at the will, let's say there are 3 children, it would say 1/3 of my estate goes to each child. But if all of the estate is in that brokerage account, then, and one individual is on that account as a joint owner, the entire estate is going to go to one person. Now, sometimes it doesn't matter. That individual will just, after everything is settled, that individual will merely gift it to his or her siblings. But I have found over and over again, what tends to happen is the individual whose name is on that account is also the individual who's caring for mom. That makes sense. That's why her name is on the account, because it's easier for her to administer mom's assets instead of having to rely on a power of attorney. So what we see over and over again is the child who is caring for mom has very often had some marital difficulties because of this, has had some employment difficulties because of this, and maybe even living in the house with mom or dad. And they feel that they're entitled to this money. They may even feel that mom or dad did it on purpose because they wanted them to have this money to compensate them for the demands that they have created on their own lives. And I don't know what everybody else's experiences are. We obviously have a lot of experiences with multiple different families, but they're always surprised. The other children are always surprised when this child will not give up the money. They say, I can't believe she's doing it. And her answer is, mom told me that this is how she wanted it done. And it's very difficult. And it's a very difficult battle to have after somebody dies. So I would say leave their names off it. Make sure you have a robust power of attorney. And one of the things that I always counsel my clients on and their family members is, as soon as you receive the executed copy and original of the power of attorney, go to all the financial institutions. The financial institutions are always going to give these documents to their legal team to make certain that they will accept them. So you will know that they are acceptable to the financial institution. If you wait until you need it, at the very best, it's going to take a week or two for them to go through it and analyze and review it. And they may find problems with it. All these financial institutions are very worried about litigation. So they're always going to look for problems with powers of attorney.